distributed exhibits. Good morning. The hearing will come to order. In January, the Integrity Committee of the President's Council on Integrity and Efficiency, PCIE, completed an investigation into allegations of misconduct by Robert Moose Cobb, the Inspector General of the National Aeronautics and Space Administration, NASA. The report was damning. The report found that Mr. Cobb abused his authority and showed a lack of the appearance of independence from NASA management, and concluded that discipline up to and including removal was appropriate. After reading the report, Chairman Gordon and I of this committee and Senator Bill Nelson, the chair of the counterpart committee in the Senate, called upon President Bush to remove Mr. Cobb as Inspector General of NASA. Mr. Cobb continues to serve at the pleasure of the President. It apparently continues to please President Bush for Mr. Cobb to serve as the NASA Inspector General. This subcommittee, will hear from Mr. Cobb and others in the next few weeks concerning the allegations of misconduct that were the subject of the PCIE report. As damning as the report was, it appears on closer examination that the report was overly generous. The subject of this hearing is the conduct of NASA officials in handling the Cobb matter. Specifically, this hearing concerns a meeting with the staff of the Office of Inspector General of NASA, a meeting that all staff members were expected to attend, a meeting at which Mr. Cobb sat beside Administrator Michael Griffin while Administrator Griffin disputed the findings of the PCIE report. NASA officials certainly have known that such a meeting would only further the appearance of a lack of independence by the NASA Inspector General. In his prepared statement today, Michael Wholley, the General Counsel of NASA, is in high dudgeon about the accounts of NASA employees who attended the meeting, which he testifies range from the patently false to the ridiculous. He asserts that this subcommittee should be skeptical of allegations slipped under the door or thrown over the transom, often anonymously or with a request for anonymity. That is exactly how whistleblowers provide information to oversight committees of Congress and to Inspector Generals acting independently as required by statute. We could have known for certain just exactly what happened at that meeting and not had to decide between wildly conflicting accounts, decide which accounts to believe, because there was a DVD made of the meeting, and then copies were made of the DVD. Mr. Wholley personally destroyed those tapes. A great American lawyer, Elihu Root, said that about half the practice of a decent lawyer is telling would-be clients that they are damn fools and should stop. That is the view of the ethical expectations of a lawyer that I learned in law school, and it remains the expectation set forth in the Code of Professional Responsibility. Instead, the view within NASA apparently was that DVDs could be destroyed absent advice, that any legal arguments that the DVDs should be preserved was, quote, categorically, fatally, legally flawed. I worry that the ethical obligations of a lawyer that I learned in law school are now regarded as quaint and antiquated like the Geneva Convention. NASA officials, Mr. Wholley and Paul Morrell, knew that there were questions about the propriety of the meeting. They knew that the Cobb matter was a subject of interest by the Oversight Committees of the House and the Senate. They knew that the DVD of the meeting would be subject to disclosure, and Mr. Wholley made a conscious decision to destroy the DVDs. It is impossible not to conclude the worst from that conduct. At this time, the Chair recognizes Ranking Member Sensenbrenner for his opening statement.
Thank you very much, Mr. Chairman. We are here today in part to reconstruct a meeting we should have been able to watch. Congress relies on inspectors general as agency watchdogs to oversee the conduct at agencies. And let me say, 10 years ago, when I was the chairman of the full Science Committee, I used inspector generals very effectively in doing the oversight that the Constitution and the public demands that the Congress do. And even though I had a very contentious relationship with then Administrator Daniel Golden, the Inspector General, who was also appointed by President Clinton, maintained his fierce independence and was able not only to give the committee relevant information on matters of concern, but according to Mr. Golden, these efforts, together with others that this committee did, made NASA a better agency. Now, because we rely on inspector generals so heavily, we take allegations against them seriously. And after a year-long investigation and deliberative process in which Congress was kept almost entirely in the dark, the President's Council on Integrity and Efficiency, the PCIE mentioned to by the chairman, forwarded its investigative committee's findings on NASA's Inspector General to Administrator Michael Griffin. Administrator Griffin, in concert with NASA senior management, reviewed the findings and recommended that the Inspector General attend management training courses. He forwarded his recommendations to the chairman of the PCIE, who adopted them. Administrator Griffin then scheduled a meeting on April 10th with staff from the Office of the Inspector General to explain his decision. By several accounts, Administrator Griffin's meeting on April 10th with the Office of the IG further undermined the IG's independence, and I am extremely concerned about that. As one NASA employee told committee staff after attending the meeting, if there was an appearance of independence before, there is now. Given our reliance on inspectors general, Congress would have benefited from reviewing a tape of that meeting. It is therefore unfortunate that these tapes were destroyed, but hopefully through testimony today we can develop an accurate picture of the meeting as possible. I would further request the chair, and I will be happy to sign a letter to that effect, to refer this matter to the Justice Department for investigation, because I believe that this tape, which was produced by a NASA employee with NASA equipment, is government property, and there are criminal penalties for the destruction of government property. But perhaps more unfortunately, we need to know why recordings of that meeting were destroyed. I believe in open government, and I'm very concerned to hear that a government employee was beating a video cassette with a plank and an agency's general counsel physically destroyed a stack of DVDs. The fact that these events happened at different locations across the country and the fact that no copies of the recorded meeting remain suggest a coordinated effort to destroy all record of the event. This destruction also seems to have occurred with limited understanding of the applicable law and under full awareness that Congress, and specifically the subcommittee, was investigating this issue. I believe that personnel decisions within the administration should be handled by the administration, and as such I support the decisions made by NASA, the PCIE, and the President. But these decisions need to be made transparently, and they need to be made in a way that preserves confidence in the Office of Inspector General and our agency's leadership. From the information that this subcommittee has received to date, there is no reason to give us any confidence whatsoever in how this matter was handled. And I hope that this hearing inspires confidence and will be able to restore at least a scintilla of faith in what is going on at NASA headquarters. Thank you.
Thank you, Mr. Sensenbrenner. Our first panel will not be providing written testimony or formal opening statements, though I understand that you maybe would like to say something extemporaneously in a moment. before we actually begin with our questions. We have asked both of them in large part to discuss the April 10 meeting that's at issue here between Administrator Griffin and the staff of NASA's Office of the Inspector General in response, the response of the staff to that meeting and the destruction of the DVDs of the meeting. Evelyn Klemstine is the Assistant Deputy Inspector General for Audits at NASA. Kevin Winters is the Assistant Deputy Inspector General for Inspections. In a senior OIG, Office of Inspector General staff meeting on April 11th, Ms. Klemstine brought up the concerns of the OIG staff that the OIG staff had raised with her about the meeting, and subsequently drafted a memo that set forth those concerns. In an interview with the committee staff, Mr. Winters also expressed reservations about the propriety of the meeting and said that he was investigating the destruction of the DVD. We want to thank both of you for being here. It is the practice of the subcommittee to take testimony under oath. Do either of you have any objections to being sworn in?
No, Mr. Chairman.
No, Mr. Chairman.
Okay. Do you have any, you also have the right to be represented by counsel. Is anyone or either of you represented by counsel today?
No, Mr. Chairman.
Okay.
No, Mr. Chairman.
All right, if you would please stand and raise your right hand. Do you swear to tell the truth and nothing but the truth? Thank you. Two quick matters. One is, before we begin, I would like to place into the exhibit of this hearing a record of exhibits that has been provided to Mr. Sensenbrenner, to the minority staff as well, and is, I believe, on the table for your reference for the witnesses, referenced by the witnesses, and without objection, it is so ordered. And then second, I know that neither of you were asked, we didn't ask either one of you to provide a written statement, but either of you wish to make any preliminary statement before we begin.
Yes, Mr. Chairman.
Thank you.
Thank you. My name is Kevin Winters. I'm the Assistant Inspector General for Investigations at NASA's Office of Inspector General. With the Chairman's permission, we'd like to provide a brief opening statement. Our intent is to provide what we hope is a helpful context regarding the organizations for which Ms. Klemstine and me are responsible. As the Chairman knows, the mission of the Office of Inspector General is to conduct objective oversight of NASA's programs and operations, and then to independently report to the NASA Administrator, this Congress, and to the public to further help NASA's accomplishment of its mission. Public Law 95-452, commonly known as the Inspector General Act of 1978, is the statutory basis for offices of Inspector General throughout 61 federal agencies, and accordingly serves as our statutory foundation for a series of broad mandates. One such mandate under the Act is that the Office of Inspector General perform two operational functions, those being audits, the second being investigations. The Office of Audits, supervised by Ms. Klemstine to my right, focuses on the conduct of audit activities relating to NASA's programs and operations. There are 101 NASA OIG employees in the Office of Audits who are deployed throughout most of NASA's field centers. Ms. Klemstine, as the Assistant Inspector General for Audits, is a 28-year career civil servant, largely in the IG community, and has been with NASA OIG since November 2004. I am privileged to lead the other operational function, the Office of Investigations, which performs investigative activities, both criminal and administrative, pertaining to NASA's programs and operations. There are 81 NASA OIG employees in the Office of Investigations, of which 58 are federal law enforcement officers who serve as special agents. Like their audit counterparts, our investigative staff is deployed throughout most of NASA's field centers. As the Assistant Inspector General for Investigations, I'm relatively new to the Inspector General community, having served in NASA OIG for 17 months. Before that, I served 30 years of uniformed service in the U.S. Marine Corps. Like Ms. Klemstine, I am now a civil servant. Finally, we are responsible for our respective functions to the NASA Inspector General, the Honorable Robert Cobb. As the Chairman mentioned, Mr. Cobb was nominated by the President as NASA's Inspector General on February 26, 2002, and confirmed by the U.S. Senate on April 11th, 2002. We are here today at your invitation, and we look forward to your questions.
Thank you, Mr. Winters. That was one of the better opening statements I have heard, certainly from a witness that we didn't ask to prepare an opening statement. If all witnesses that we didn't ask to prepare an opening statement gave one like that, we would not ask more often. At this point, I'll recognize myself for 5 minutes and Mr. Sensenbrenner for 5 minutes. If any other members attend, they will be entitled to 5 minutes of questioning as well. We will rotate back and forth until we've completed the questions that we have of you. Mr. Winters and Ms. Klemstine, you did both hear of the all-hands meeting on April 10th. How did that email, how did you hear of that meeting?
I received an email from the Deputy Inspector General stating that there would be a meeting on April 10th that was mandatory for all staff members.
Okay. Mr. Winters?
The same thing. There was an email on April 9th, I believe was a Monday, late in the day. I want to say about 5 o'clock from the deputy.
And the deputy was
Mr. Tom Howard.
All right, thank you. If employees cannot attend all hands meetings at which every member of the staff is expected to attend, has it been the practice to have a recording of that meeting for those employees? And is it reasonable to do so?
Yes, every all-hands meeting I've been to, as well as some ethics training and other meetings where everybody's required to go to, have always been videotaped.
Yes, I think it's a reasonable idea that people can come back and look at a tape. In this case, I don't have a recollection that it was mandatory to go back and look at a tape, though.
Okay. Mr. Winters, you told our staff that Mr. Cobb, Mr. Howard, Ms. Klemstine, and you were in the meeting room when the administrator, Mr. Griffin, came in, and Mr. Morrell and Mr. Wholley. You said to our staff that there was tension in the room. What was the nature of the tension? Could you describe the atmosphere in the room?
Sure. It was a room in the basement of the NASA headquarters building, tiered seating. All the NASA OIG employees were present in the room that worked in the headquarters building, and the screen to our front was the 9 respective NASA field centers that were displayed up on the screen. The purpose of the meeting was generally known, that the administrator was going to discuss more or less his review and findings, or was assumed that he's going to discuss his review and findings of the PCIe investigation. So there was a natural, in my opinion, tension that the administrator is going to discuss allegations of misconduct of our boss. So it was quite reasonable to have a feeling of tension about that.
Okay,
with our boss present.
Sure. Mr. Winters, you told our staff, our subcommittee staff, that you knew instinctively that this meeting was a mistake, that it gave a perception of a lack of independence of the Inspector General. Is that your testimony today as well?
And that might be a bit of an overstatement, but in my opinion, it's difficult to have that type of a discussion with your boss present.
So it was the appearance. Well, you told the staff that there were visuals that raised questions by you and by other members of the staff. What did you mean by that?
The optics of the head of NASA, the administrator, reviewing a report of allegations in front of the Inspector General and speaking to the staff about it. As I said, the optics of just those people in the same room talking about this particular subject.
Okay, so in Washington, we would say that there was a problem with the optics outside of the Beltline, and the rest of Americans, they'd say it looked bad.
I think that might be an overstatement, Mr. Chairman, but the optics did raise issues, obviously.
Okay. Ms. Klemstine, do you think it was a bad idea? Did you think so at the time? Do you think so now? To have the meeting with Mr. Cobb present?
I was in favor. I definitely felt that Mr. Cobb should not be there. I was surprised that he was at the meeting. I had not had that expectation. However, what I was looking for at that meeting was basically, quote unquote, a pep talk. I felt like our organization needed somebody to come in and tell us that we were valuable to the organization, that we provided some input, and that's what I was looking for. So I wasn't opposed to having the meeting, but I didn't agree with the content of the meeting.
Okay. Ms. Klemstine, did your senior staff express any kind of concern to you about the meeting?
Not prior to the meeting, but after the meeting.
Okay. What was the nature of their concern?
Some of the comments made by the administrator as they related to the audit community.
All right, I'm going to go over my time just very briefly. I'm going to refer to a memo dated April 23, 2007. That is Exhibit 1 in the book in front of you. Could you tell us what that document is?
Yes, it's an email that I prepared for the Deputy Inspector General. The day after the administrator had spoken with us, Wednesday, we had our senior staff meeting, as we do every Wednesday. And at the senior staff meeting, I expressed at the meeting that my staff had concerns about some of the content of the VITs. At that time, I was told to basically document those concerns, and this is a result of that documentation.
Okay. And the concerns were that it was not appropriate for Mr. Cobb to be at the meeting?
Yes.
Certainly not if Mr. Griffin expected an open discussion with the staff. Is that?
Yes, that's correct.
And did Mr. Cobb ever address the appearance, the issue of the appearance of a lack of independence, and what would be done to correct that appearance?
At the meeting itself?
I meant Mr. Griffin is what I meant to say.
Did he address, I'm not quite sure I understand the question.
Was one of the concerns that your staff expressed was that Mr. Griffin never addressed the principal concern of the PCIE report, that Mr. Cobb failed to maintain the appearance of independence?
Yes, that was one of their concerns.
That Mr. Griffin never addressed that?
Yes.
That concern. Okay. And did Administrator Griffin also express, describe the work of the OIG?
He described the work in terms of what it was that he thought we ought to be concentrating on, or areas that he thought that we should do, such as fraud, waste, and abuse, and other areas where he didn't think that we added value to the community.
All right, and did your staff express to you how they regarded Mr. Griffin's statement? Did they find him disheartening?
Yes, several people were quite upset about some of the comments.
Okay.
Especially my technical staff.
Okay, and did Mr. Griffin make say anything about the technical expertise of the staff?
Yeah, he basically said that the audit community didn't have the ability to make technical type, I don't want to say decisions, but recommendations, I guess would be the correct word. Those weren't his exact words, but in generality.
Okay, the staff lacked the technical competence to...
Right, exactly. That, he had engineers and technical people on his staff that were more technically knowledgeable than those that would be on an audit staff, even though I do have engineers as well as software engineers as part of my staff.
Okay, so this is, expecting a pep talk, you got something very different.
That was my expectation, yes. I was looking for, because I've been there for 2.5 years and we've been under this cloud, and I really wanted, not only for myself but for my staff, some feeling of adding value to the organization.
Okay. Mr. Sensenbrenner.
Thanks very much, Mr. Chairman. I'd kind of like to go on the broader issues. Do you think the impression that was given by Administrator Griffin's talk to the IG staff was appropriate?
No.
And why?
Again, as I stated earlier, I really felt that he did owe us some type of a pep thing, but I didn't think that he should go as far as making comments about the fact that, if it wasn't $1 billion worth of savings, it wasn't worth reviewing that we didn't have the technical expertise to do certain types of jobs and that our jobs should be basically focused on fraud, waste, and abuse.
You think that Administrator Griffin's comments undermine the independence of the IG staff? Either of you?
I think that would be an individual-to-individual comment. Personally, it did not undermine my independence because I've been in this community a long time and I know that people make comments specifically on the audit side, but I do know that many of my staff members did feel undermined by his comments.
Now, did Administrator Griffin make these comments in response to a question, or was this just something that he said on his own and not in response to any questions by the audience?
It was in response to a question from the audience.
Okay. And what was, if you can recall, what was the nature of that question?
The nature of the question that was actually from not somebody from the audit community was specifically, what type of audits do you think we should be doing?
And that question, which came from outside the audit community, and the answer of Administrator Griffin, in your opinion, did it undermine the independence of the audit community to be able to do its job?
Again, I'm not sure it undermines. It does leave an impression.
Okay.
I mean, we're going to do what we need to do, but it does leave what's the value? If the administrator is not interested in his work, then how are we contributing?
Well, he might not be interested, but we are.
Right, right, granted. Yeah, and that's why it doesn't undermine, because obviously you're our preponderant customer, so, you know, that's just one part of the equation.
Not only the customer, but the sugar daddy that gives you money every year, too.
Right.
Mr. Sensenberger, may I piggyback on that line of questioning? The administrator was very careful in terms of his prepared remarks, and I think this committee has a copy of the prepared remarks. He actually worked from a list of talking points in terms of what he wanted to communicate with our staff. And the comments that Ms. Klemstine is referring to were in response, of course, to questions. And it was my impression, again, we're in the world of perceptions and how you view evidence and how you view statements, that the administrator was very careful in qualifying his remarks, because he was being asked as to his opinions as to what mattered to him in terms of our work, the priority, the type of works that we do. And he went on at great length about he valued very much the fraud, waste, and abuse type investigations that we do. And then he went into his opinions as to management type recommendations, which he hears apparently, you know, according to him, every day in terms of winners and losers on decisions that are made. So you know, it was my impression that he was saying that they're not as much helpful to him in terms of the work the OIG does as compared to the typical criminal fraud, waste, and abuse investigations.
When did you first learn that the meeting was recorded, both of you?
It was on the screen there. There were several signs in the room that said that this is being recorded.
That's true.
And when did you first learn that the meeting should not have been recorded?
I never heard that the meeting should not have been recorded. What I did hear was the following morning I received an email from one of my staff members telling me that they were told to destroy the tapes. And that was my first knowledge that there was any type of concept of tape destruction.
I first learned on Monday. Monday, I think it's the 16th or 17th of April. I might have my dates wrong on that. It was after the weekend. The meeting occurred on April the 10th, which I believe was a Tuesday. I had some evidence that employees were asking for the tapes on that Friday, the following Friday.
Are these types of meetings usually recorded?
Yes.
Both of you say yes?
Yes. And they're fairly rare, Mr. Sensenberger, in terms of all-hands meetings. This is the first all-hands meeting that we ever had with the administrator since I've been there.
If I can run over my time a little bit too, have either of you ever requested that a meeting of this type be recorded?
No.
No.
Thank you very much, Mr. Chairman.
Mr. Brenner, I ran over 3 minutes. You could have gone another couple minutes if you wanted to. Follow up on that last question, have either of you requested the meeting not be recorded?
No.
No.
Mr. Winters, you referred to Administrator Griffin's opening statement being in writing. We actually do not have a copy of that. It is hard to imagine our request would not have reached a copy of that prepared statement. But can we receive that from you?
Well, we certainly have access to all NASA documents, and we'll make a request to get that.
Okay, right. I'm sorry. You can go answer this question quickly. Excuse me.
We can request a document for you.
Okay, I neglected to notice that Mr. Feeney was here, and he was entitled to 5 minutes of questioning as well. Mr. Feeney?
Well, thank you, Mr. Chairman. If now's the appropriate time, I probably won't have 5 minutes worth, but for both of the witnesses, my understanding is that your office is to function totally independent of the administrator's supervision or control. Is that right?
Under the IG Act, we're under what's called the general supervision of the head of the agency, which is a term that is often debated in the periodicals. But yes, we're independent in terms of
your mission is to be
what we decide to investigate or audit and things like that.
So, for example, if the administrator had told you not to investigate abuse, waste, or fraud, you would have been required to ignore those instructions.
Correct. We make our independent assessments as to what to do.
In his original letter calling the meeting, Mr. Griffin said that he had reviewed the ROI, and I have taken actions that I believe are necessary to address the ROI's findings. Did he express that in his statement that we don't have a copy of?
Yes, he did. I don't know what was on the statement. I presume it was a written statement, 1 page, and he had some talking points which he appeared to have read. He read from these talking points in terms of why we're at the meeting, that he was requested to provide input to the chair of the PCIE, and he went through the chronology as to how we got to this particular place, that he reviewed an investigation, and he's making the following recommendations.
Other than saying that with respect to the technical expertise in running the agency, he felt like he had people more suitable and qualified, did he, in general, give support to your office in terms of your mission and in general express sympathy or empathy with the jobs that you had and support for what you do?
Well, we represent 2 separate functions of the Office of Inspector General. From my functional area, the Office of Investigation, my staff was supportive. Good for the administrator. He's all about finding out fraud, waste, and abuse, and supports us.
And Ms. Klemstine?
From my staff's perspective, not as glowing. There were concerns about, especially since I do have 2 groups that specifically lean towards the technical area, both my Science and Aeronautics Research Group as well as my Space Operation and Exploration Group. And they do more technical type audits as well as make technical recommendations. So there was some concern in those, specifically in those 2 areas.
And these concerns were expressed to you after the meeting?
Yes.
Were they expressed during the meeting to the administrator?
No.
And was there a reason that they were not expressed during the meeting?
No, I can't answer that question. I have not asked that question, nor do I know any reason why it was not expressed.
Did anybody express at the time that they felt it was inappropriate for Mr. Cobb to be in attendance at the meeting? During the meeting, did anybody tell the administrator they would be more comfortable?
No.
Okay. I have no further questions.
Thank you. Ms. Klemstine, we spoke for a moment about how both you and Mr. Winters first heard that the tapes were being destroyed. And I think you said you'd gotten emails. I think according to your interviews with our staff, Karen Van Sant was involved in the email exchange.
Actually, it was Susan Ogden who mentioned Karen Van Sant. She was the one who actually had sent the email that Karen had been told to.
Okay. All right, and then Catherine Snyder?
Snyder, yes.
Schneider?
Yes.
Okay. And what did she tell you about the DVDs?
Well, the first is, and I believe that you have a copy of that, was an email that she sent to me and saying that they had asked for the destruction of the tapes, and I wrote an email back in response to that saying, why are we doing this? And then I went actually down to physically talk to her as to why was this occurring, because in my mind it sent up a bunch of red flags as to why would we destroy tapes.
Okay. You mentioned emails. It's Exhibit 5 in the briefing in the exhibit book before you. Are those the emails that you've referred to?
No, this one's from Dave Gandrew to Catherine. It was a different
I've got the
email.
wrong number. Exhibit 2.
Yes.
All right. Did you consider telling Ms. Van Zandt or Ms. Snyder not to destroy
Yes.
the tapes?
Very much so. I did.
Okay. You considered it? Did you do it?
No, I did not do it.
Okay.
And I did not do it because I was not the originator of the document.
Okay. Do you feel any twinge of regret in that
Yes.
decision?
Yes. I remember sitting at my desk when I got this email, and I remember thinking, geez, we should not be doing this. You know, the price to pay for destroying a document versus what was on the document, to me, wasn't worth the expenditure. And I did go and talk to Catherine about, can't we try to keep it or whatever, and I did discuss it at my level, but I did not pursue it any higher than my level.
Okay. Did you discuss this with Mr. Winters?
No, he was not there at the time.
Okay. Did you discuss him with it at any time?
No.
Okay.
You have to realize that the tapes were destroyed the following morning, like 8 or 9 o'clock in the morning. It was so quick. It was done within less than 24 hours.
All right. Did you hear Mr. Winters at any time tell the staff of the OIG office that destroying something always raises red flags? You used the phrase "raises red flags" a moment ago.
Did I hear Mr. Winters make that comment? No, I did not.
Okay,
That
Mr.
was
Winters. Now, what was your response when you heard of the order to destroy tapes, the DVDs?
Maybe the chronology of getting there might be helpful to the chairman. My first knowledge that they were my first time I heard that the tapes were destroyed was the following week when I talked to the chief of staff of NASA.
Okay. Did you tell your staff at any point that destroying something always raises red flags?
I might have.
Well,
It's a reasonable statement to make, and then one that I would hold today.
okay. Whether you said it or not, you thought it then, you think it now?
Correct.
Okay. Mr. Winters, did you begin an investigation of any kind into the destruction of the
Yes.
Okay. When did you do that?
Upon learning that the tapes were destroyed, and I went back and talked to my leadership as to next steps in terms of what to do.
Who were your leadership?
The Deputy Inspector General, Mr. Tom Howard.
Mr. Winters, I know that you are a lawyer. Are you familiar with the evidentiary concept of spoliation, S-P-O-I-L-A-T-I-O-N?
Probably not as much as I should, but maybe the chairman could share that with me.
Well, let the word go forth that any lawyer who appears before this committee should be expected to be quizzed about the law. Is there any element of what you understand spoliation to mean, that when a party, knowing that evidence will be of interest to another party because of pending litigation or anticipated litigation or the interest of an oversight committee, destroys a document that would be of interest, that the inference about what was in the document is damning to the person who destroyed it. Is that your understanding of
Oh,
that?
I agree with that.
Okay. Is there any element of spoliation that does not fit these circumstances?
Here's not.
Mr. Sensenbrenner?
Thank you. For either of you, were OIG employees looking for copies of the destroyed tapes?
It's my understanding there were some employees that missed the meeting and were looking for the tapes so they could view the meeting themselves.
Yes.
What was your reaction to when you received the email asking that copies of the tape be destroyed?
I think that question applies to me. As I stated earlier, when I was sitting at my desk reading that email, my thought was, why are we doing this? This is not the right thing to do. So, as I said, red flags went up in my head.
When the red flags went up, did you do anything in response to those flags?
I went back to the originator of the email, Ms. Schneider, and asked her specifically, what's the story here? Why are we doing this? Again, the email actually came out of Marshall, which is one of our field centers where I first obtained the knowledge that this was going on. I was not familiar with the headquarters situation at all. And I was basically told that there was somebody standing there waiting to take the tape from the VIT's office, and that basically they had already given the individual the VIT's tape.
Ms. Klemstine, you've been in the IG's office for a long time. Have you ever received a request like this?
No.
And why do you think the NASA headquarters wanted those tapes destroyed?
I truly do not know why. Again, the price of destroying those tapes was not worth, in my mind, what was on those tapes. And so I cannot think why we would do that.
Mr. Winters?
I can only speculate.
And who do you think was behind the decision?
To destroy it?
Yes.
Probably the combination of either chief of staff and the general counsel.
Klemstine?
I would say the same. I have no knowledge.
Okay, I have no further questions. We'll be hearing from them in a few minutes.
Mr. Feeney?
I have no further questions, thanks.
I'm sure that you'll be disappointed that that's the end of our questions for you. And if we could take a recess of just a couple of minutes, we'll have our next panel. Thank you. subcommittee will return to order. And we now welcome our second panel, Michael Wholley, the General Counsel of NASA, and Paul Morrell, the Chief of Staff for NASA Administrator Michael Griffin. It is, as you know, the practice of the subcommittee to take testimony under oath. To either of you have any objection to being sworn in? Okay. You also have the right to be represented by counsel. Are you represented by counsel today? If you would now please stand and raise your right hand. Do you swear to tell the truth and nothing but the truth? Thank you. Both of you have provided written testimony, and I assume that your oral testimony will be very similar to that, probably simply reading that. If you could begin with limiting that testimony to 5 minutes, all of your written testimony will be placed in the record, and after that we will ask questions in turn as we did before. We will begin with Mr. Wholley. Mr. Wholley.
Thank you, Mr. Chairman. Sensenbrenner, Mr. Feeney. I've been asked to address 5 issues in my testimony today before the subcommittee. As you may be aware, I met with the staff of the subcommittee as well as with the staff of other committees on April 27th for approximately 3 hours and addressed these 5 issues, as well as others, and answered to the best of my recollection and belief all of the questions posed to me. You asked me to address the April 10th meeting held by Dr. Griffin. Dr. Griffin set out as his purpose for that meeting what he put in his March 14th letter. I will schedule a meeting, quoting Dr. Griffin, with the employees of the NASA Office of Inspector General to inform them that I have reviewed the ROI, the Record of Investigation, and I have taken the actions that I believe are necessary to address the ROI's findings. Such a meeting will provide me an opportunity to listen to any concerns that may exist among the staff and to express my support, that would be Dr. Griffin, for a strong and effective Office of Inspector General. I was in attendance at the meeting, arriving with Dr. Griffin and Mr. Morrell, the Chief of Staff. The meeting was held in the video conference room on the lower level at NASA, and Dr. Griffin spoke initially for approximately 10 minutes. He stated, as best I recall, something similar to what he had set forth in his letter to Mr. Johnson with respect to the ROI, having revealed no evidence of a lack of integrity on the part of Mr. Cobb, nor did the ROI indicate any actual conflict of interest or actual lack of independence on his part. I had watched Dr. Griffin's interview on the C-SPAN program Newsmakers on Sunday, April 8th, which is still online, and his remarks at this meeting were similar to those he had articulated on that program. Dr. Griffin then opened up the floor for questions, and several questions were asked and answered. I believe that the meeting lasted a total of approximately 30 minutes. With respect to the subsequent collection and destruction of all video records of Administrator Griffin's meeting with the OIG staff, my involvement is as follows. At some point on the morning after the meeting, Paul Morrell came into my office. This was not an unusual occurrence. He had what turned out to be several DVDs, and he sat at a table across from my desk. He appeared upset that in spite of his direction to the contractor that this closed meeting was not to be recorded, the meeting had been recorded. As best I recall, he stated that someone in public affairs had asked that the meeting be recorded and had then asked that a number of copies be made. Mr. Morrell indicated that he had recovered the copies from public affairs and that this meeting was not a public affairs event, but rather a closed meeting called by the administrator for the purpose that the administrator set forth in his letter. I believe I told him I clearly understood his pique, that his direction had been overridden, and that this closed meeting had been recorded and that copies had been made. I believe that at the conclusion of our discussion, I asked him to leave the recordings with me, and I put them on my desk. I want to categorically state, at no time and in no way did Mr. Morrell indicate to me that I should destroy these recordings. That did not happen. Sometime either later that day or early the next day, I honestly can't recall when, I reviewed relevant portions of the Federal Records Act, and in particular the definition of what constituted a record. I also briefly reviewed the Freedom of Information Act. I concluded that these copies made by Public Affairs were not records for purposes of the FRA, but also concluded that if they were retained and filed,
they could become records by virtue of that retention. From my perspective, and I stated to the subcommittee staff, I did not believe it wise to have these in any way become records subject to release under FOIA. This was a closed meeting specifically directed to not be recorded, and these DVDs were not agency records at that time, in my opinion. I personally made the decision to destroy them, and I did so by breaking them into pieces and throwing them in the trash. The next time I heard anything about these recordings was while I was on vacation in Florida the week of April 15th at a family reunion. In looking at my emails, I believe I first learned of the request to provide a copy of the recording to this subcommittee sometime in the late afternoon or the early evening of April 18th, when I learned of the subcommittee's letter of the same date. I informed my staff I didn't have any copies of the recording and that I had previously destroyed them. At some later time, I learned that there had been other recordings made at other VITS locations. Regarding my role in the response by Dr. Griffin to the report of the Integrity Committee, I became aware that something had been sent to Dr. Griffin from Mr. Johnson in his role as chairman of the PCIE. I'll try and skip forward to stay within my 5 minutes, sir. I think I received this from Mr. Morrell on Monday the 26th. He gave me what had been delivered to Dr. Griffin. I asked my executive assistant to print all the documents out from the CD that was provided, and I made arrangements to meet with Dr. Griffin and discuss how he wanted this handled. He indicated that he wanted the matter reviewed and that he wanted to know the full range of options open to him. Specifically, I might add, he said, I do not want a recommendation, I want to know what my options are. At some point, either the 27th or 28th, I discussed it with my deputy. I discussed the possibility of having a newly hired individual, an experienced attorney who was due to begin working on my office the following Monday, look over the report and provide me her unvarnished opinion. I believe this was a good option in light of her extensive experience and the fact that, so far as I was aware, she knew nothing about any of the matters of the parties involved. I asked Mr. Sefton to call her, confirm that she knew nothing about the case, and ask her if she could begin working on it at the earliest opportunity in light of the tight deadline that we were facing. I concurrently reviewed the materials. At the conclusion of her review, she provided me her opinion. I arranged for a meeting to brief Dr. Griffin and had her, the newly hired attorney, brief him on her review. At the conclusion of that review, I indicated my full concurrence with her analysis. I then left all the materials with Dr. Griffin, informed him that under the terms of the executive order, he was required to certify that he had reviewed the investigation, and that once he had arrived at his course of action, we'd prepare the transmittal letter back to Mr. Johnson. The rest of that paragraph deals with how that letter was sent back. I've been asked to address concerns about the monitoring of Mr. Cobb's actions under the corrective action plan proposed by Administrator Griffin. Administrator Griffin set forth his recommendation in his March 14th letter, and that's available to you, and I'm sure you have it. I have no role in that monitoring process. The IG Act specifically authorizes the general supervision can be by the principal deputy, but cannot be delegated any further. Of course, there still exist all the options available to any individual who wishes to file a complaint against the Inspector General, including the Integrity Committee, the EEO process, the Office of Special Counsel, and others. Dr. Griffin has publicly and privately stated that he wants an independent Office of Inspector General committed to its statutory charter. I've been the General Counsel at NASA since July 6, 2004. This is in reference to my personal relationship, allegedly, with Mr. Cobb. My relationship with Mr. Cobb is professional and amicable. Do we socialize together? No. I've never been to his home nor he to mine. We are professional colleagues. As I stated to the staff during our 3-hour meeting, I find him to be a man of integrity. From my perspective, he understands his role as Inspector General and carries it out with conviction and force, and we understand our boundaries well. I was asked how often I talked with him. The answer is simple: every time I see him. We have worked together to establish an acquisition integrity program, for example, and both of us and our respective staffs firmly believe that it will pay great dividends to the agency and to the government. We also have disagreed on numerous occasions on the law. And he has the impediment of being as stubborn and oftentimes as argumentative as I am when we believe we're correct. We have on a number of issues agreed to disagree. Not sure how much more of my 5 minutes are here, sir, but As I stated to the staff with whom I met on April 27th, I do not think that anybody, and I've said this to the staff, I do not think that anybody wishes more than I do that a recording of that meeting could be provided to this body. There were somewhere between 120 and 200 people, I believe, at that meeting. The vast majority, in fact, almost exclusively, OIG people. I believe the only two non-OIG were probably Mr. Morrell and I, and then, of course, the administrator. To in any way imply I destroyed copies of the recordings in an attempt to destroy evidence of the substantive content of that meeting is just not true, sir. Not my intent. I recognize that memories and perceptions about what occurred there differ. And the rest, sir, you've commented on. I'm not in high dudgeon or in a fit of pique. I'm just skeptical about anything that comes in front of me. And you have every right to be skeptical as well. Finally, I want to publicly apologize to everyone at NASA and this committee who's had to expend time and effort trying to find out whether a copy of this record still exists. I want to particularly apologize to Dr. Griffin and the leadership at NASA. The agency has important work to do for this nation and its people, work that's critical to our national security, our economic future. Distractions like this are not helpful, and I deeply regret that I have made this a distraction. I spent my professional life trying to resolve problems and trying to make things better. Despite my honest and considered efforts in the matter of the destruction of the DVDs, I regret I failed to do so in this regard and necessitated this hearing. Thank you, sir.
Mr. Morrell.
Thank you, Mr. Chairman Miller, Ranking Member Sensenbrenner, and Mr. Feeney. In his March 14, 2007 letter to Clay Johnson, Chairman of the President's Executive Council on Integrity and Efficiency, NASA Administrator Michael Griffin wrote, I will schedule a meeting with the employees of the NASA Office of Inspector General to inform them that I have reviewed the report of investigation regarding the allegations of misconduct on the part of NASA Inspector General Robert Cobb, and I have taken the actions that I believe are necessary to address the report of investigation's findings. Such a meeting will provide me an opportunity to listen to any concerns that may exist among the staff and to express my support for a strong and effective Office of Inspector General. A subsequent letter to Clay Johnson dated March 29, 2007, Administrator Griffin wrote, in my meeting with IG Cobb and the OIG staff, I will make clear that I expect and support a strong OIG, which continues to be dedicated to identifying fraud, waste, and abuse, and that I am committed to leading an agency where full and frank discussions are not just tolerated, but are expected, condoned, and encouraged in a climate without fear of retribution, and one in which the full panoply of protections exists for whistleblowers. The meeting between the Administrator and the Office of Inspector General staff took place on Tuesday, April 10th. The previous day, on Monday, April 9th, I contacted the Office of Public Affairs to inquire about using the NASA TV facilities available in the headquarters auditorium for the April 10 meeting, which included OIG staff at headquarters and the various NASA centers across the country. The meeting was on a sensitive subject, and I wanted the OIG staff to feel free to participate in a full and free dialogue. Therefore, I asked Public Affairs to determine if the equipment used in the auditorium could limit the broadcast of the meeting solely to meeting participants. Later that day, I was informed that the auditorium equipment would not allow the meeting to be limited to participants, and it was recommended that the headquarters video conferencing facility be used instead. Concerned that the size of the video conference facility was not adequate to accommodate the number of OIG staff expected at the meeting, I went to the facility and spoke to its manager, Mr. Fred Berger. During my conversation with Mr. Berger, we discussed whether the technology in the auditorium could be used, whether the technology available in the video conference center could be used in the auditorium, and whether the video facility could accommodate the number of OIG staff expected to attend the meeting. I also told Mr. Berger during our conversation that the meeting should not be recorded. My reason for doing so was my belief that recording the meeting might discourage questions and discussion of OIG staff concerns, which was inconsistent with what I believed was the Administrator's stated purpose for the meeting. The next day, on April 10, shortly after I arrived at the meeting with the administrator, I noticed a display on a video monitor at the front of the room that indicated the meeting was, contrary to my instructions, being recorded. Later that day, I placed a call to Mr. Berger to inquire why the meeting had been recorded. Mr. Berger was unavailable, and he returned my call the following morning as I was driving to the office. I asked Mr. Berger who recorded the meeting. He said he did. I asked him why he recorded it contrary to my direction. Mr. Berger said he forgot that I had asked him that it not be recorded, and that Mr. Fred Brown from NASA TV, under the Office of Public Affairs, had requested that the meeting be recorded, and that Mr. Berger had provided Mr. Brown with a copy of the recording. I told Mr. Berger that I thought it was highly inappropriate for someone in public affairs to request a recording of a meeting between the OIG staff and the administrator, especially when I told him the previous day that it should not be recorded. I asked Mr. Berger to retrieve the recording from Public Affairs. I next spoke by phone with my secretary, who informed me that Mr. Bob Jacobs of the Office of Public Affairs had delivered DVD copies of the meeting to my office. I was, needless to say, surprised to learn that not only had the meeting been recorded and provided to Public Affairs, but that Public Affairs was making copies. When I arrived at the office, I went to see Mr. Jacobs. I asked Mr. Jacobs if he had requested that the meeting be recorded. He said that he had. I told Mr. Jacobs that I believed it was highly inappropriate for him to have requested a recording of a closed meeting between the administrator and the OIG staff. I told him that he did not have the authority to request recordings of the administrator's non-public affairs related meetings. I requested that he provide me with any additional copies that he had in his possession, which he in turn did. I then went to see Mr. Fred Berger at the conferencing facility. When I arrived at his office, he was there with Mr. Fred Brown from NASA TV. Mr. Berger gave me several more DVDs. I asked him if what I had in my possession represented all the copies. He said yes. I took the DVDs to the NASA General Counsel. I explained to Mr. Mike Wholley, what had happened, that a non-public affairs related meeting had been recorded by Public Affairs without proper consent or authorization, despite the fact that I said it should not be recorded. I asked Mr. Wholley what I should do with the DVDs. He said I should leave them with him. I left the General Counsel's office believing they were in the appropriate hands. I never directed that any DVD or recording be destroyed. It was my understanding that the original recording had been made at headquarters and that all existing copies had been taken to the Office of the General Counsel. To the best of my recollection and belief, I was unaware that copies of the meeting had been made and destroyed at NASA centers until sometime after the April 10 meeting had occurred, and I believe, to the best of my knowledge, it was sometime the following week. It was and remains my strong belief that the Office of Public Affairs had no legitimate reason or authority to request, copy, or possess a recording of what was a non-public affairs related meeting between the administrator and the OIG staff. Furthermore, it was and remains my very strong belief that participants in a closed meeting have the right to expect that the contents of the meeting will remain secure and private even when they know the meeting is being recorded. It was my very strong concern that the possession of the recording by Public Affairs compromised the foregoing. Subcommittee asked me to address my role in the administrator's response to the report of the President's Council on Integrity and Efficiency. My role was as a facilitator, scheduling meetings, conveying information, and coordinating the preparation, editing, review, and approval of correspondence. I did not review the report of investigation, and I did not make recommendations to the administrator regarding his response to the report of investigations. As you know, the administrator recommended several actions to the chairman of the PCIE and obtained his concurrence consistent with the Inspector General Act. Those recommendations included IG Cobb's attendance at the Federal Executive Institute courses and the assistance of an executive coach to help enhance IG Cobb's leadership and management skills. In addition, IG Cobb will meet with the Deputy Administrator on a bi-monthly basis to discuss the implementation of his individual leadership and management plan and his work with the executive coach.
The Deputy Administrator's meetings with IG Cobb will be one way of monitoring his progress and his commitment to improving his management skills. In addition, there are a number of options available to OIG staff to report any future allegations of inappropriate actions.
Thank you, Mr. Morrell. On the documents, or most of the documents that NASA has provided in response to this committee's request, there is stamped in large type across the face of the document in a way that almost obscures the contents of the documents, makes them very hard to read. And in the original, I understand that it is in red ink. This document is provided by NASA solely for congressional use and not for further release. No waiver of FOIA exemption or internal agency working document, pre-decisional attorney-client privilege are waived in this provision for congressional use beyond the purposes of the committee's making the request. To whom is that warning intended?
Sir, I don't believe it's a warning. I believe it's a recognition that these are, in many cases, pre-decisional documents that would not be releasable under FOIA, and it was not intended certainly as a warning to this committee.
All right, do you contend that this committee cannot release the documents that you have provided us under our oversight authority to the public?
Sir, if we were requested for them, we would deny them under FOIA.
Okay, but you don't claim that this committee cannot.
I make no such claim.
Okay. I am struck by two provisions of passages in Mr. Morrell's testimony and Mr. Wholley's testimony. Mr. Morrell, you quoted the letter from Administrator Griffin on the first page of your testimony. I am committed to leading an agency where full and frank discussions are not just tolerated, but are expected, condoned, and encouraged in a climate without fear of retribution, and one in which the full panoply of protections exist for whistleblowers. Mr. Morrell, do you think that is the climate in which NASA and every agency should conduct their business? And Mr. Wholley, do you agree with that?
Yes, sir.
Okay. Mr. Wholley, in your testimony, you said, my sense is that the allegations have been slipped under the door or thrown over the transom, often anonymously or with the request of anonymity, and in all too many cases they are immediately given a mantle of credibility because they originate from someone, quote, familiar with the issues, and therefore, quote, must be true. In the best of all possible worlds, individuals making such allegations would be required to swear to the truth of what they are saying and would be made aware of the consequences of any false statement. Mr. Wholley, aren't we talking about the same people? Aren't we talking about whistleblowers?
Sir,
People who throw allegations over the transom to us?
Sir, this was not referring to things that have come before the committee. It was referring to the number of allegations against Mr. Cobb in that report of investigation, many of which were unfounded, some of which were dismissed out of it.
Those were from NASA employees that were whistleblowers.
I'm not sure who they were, sir, and I'm not sure how many of them would qualify as whistleblowers.
Okay. Well, it seems like there's some category of a NASA employee that's a whistleblower, and that's a good thing. That's a wholesome thing. They're patriotic Americans. And then there's some other category of NASA employees who throw things over the transom and request anonymity for it that is an unwholesome thing. Can you tell us how we're supposed to tell the difference?
Sir, I'm not saying that one should try and distinguish the difference. What I said was when they come in that way, one needs to, as best as possible, try and find the factual underpinnings for whatever's being said, as opposed to taking it as gospel as it comes through.
Okay. Mr. Morrell, you spoke approvingly, or quoted approvingly from Mr. Griffin's letter, how whistleblowers should be regarded and protected. Do you see anything in Mr. Wholley's testimony that is contrary to how you describe the way whistleblowers should be treated or regarded?
I don't want to speak for Mr. Wholley, but I do believe that whistleblowers should have all the protections afforded under law.
Mr. Sensenbrenner. I'll have time for additional questions.
Thank you, Mr. Chairman. I want to get to the tape of the meeting and what happened to it. And I have 44 United States Code, Section 3301, and I'll quote it in total. As used in this chapter, records includes all books, papers, maps, photographs, machine-readable materials, and other documentary materials, regardless of physical form or characteristics, made or received by an agency of the United States under federal law in connection with a transaction of public business and preserved or appropriate for preservation by that agency or its legitimate successor as evidence of the organization's functions, policies, decisions, procedures, operations, or other activities of the government, or because of informational value of data in them. Library and museum material made or acquired and preserved solely for the reference or exhibition purposes, extra copies of documents preserved only for the convenience of reference, and stocks of publications or processed documents are not included. Now, from that, it appears that the tape was a public record that was at least preserved for a brief period of time or appropriate for preservation because it did deal with the functions, policies, decisions, procedures, operations, or other activities of the government. So I think it is very clear that the tape was a public record. Now, it's also a crime to destroy public records. Mr. Wholley, with your legal analysis of having these records destroyed, were you familiar with the litigation relative to Henry Kissinger's notes while he was at the State Department?
No, sir, I cannot own up to some familiarity with it.
Okay, well, let me tell you what they said. First of all, in Reporters Committee for Freedom of the Press versus Vance, which was decided by the U.S. District Court for the District of Columbia, the notes that were made of Kissinger's conversations while at the State Department were federal records under the FRA. Then that case went up and there was other litigation, and it said the determinant factor for creating a federal record is whether the record was made at government expense, that is, with government materials and on government time. I think very clearly this tape was made at government expense, with government materials, and on government time. Have you ever been asked to give advice to anybody in NASA relative to what records can be destroyed, and if so, what was that?
No, sir, I can't say that I've been personally asked to give advice to anybody on that.
Well, isn't it your job when an issue like this comes up and you were personally involved in destroying at least the tapes that were in the NASA headquarters, that you should be concerned about what the law is on this subject?
Yes, sir.
Okay. Is it your belief that the tape, once it was made, was a government record?
No, sir.
Why not?
Had that been my belief, sir, I would not have destroyed it.
Well, why not? I read the relevant portions of the law.
Yes, sir.
I read the determinate cases when Mr. Kissinger claimed that his notes should be private and not a government record. You know, it isn't very hard to dig the cases out. Isn't that the job of a general counsel to do that?
Yes, sir, it is.
Okay, well, it wasn't done. Now, Mr. Morrell, you testified you didn't have anything to do with the destruction of the tapes. And did you speak to the technician, Mr. Berger, who made the tapes after the teleconference?
The next morning, sir.
Okay. And after your conversation, did Mr. Berger erase his copy of the teleconference and called NASA centers up asking them to do the same?
I've heard that he had.
Okay. Did you ask him to do it? Okay.
It was my understanding that the recording had been made at headquarters.
Who is Keith Thomas Sefton?
He is Mr. Wholley's deputy.
So he's an attorney as well? Mm-hmm. Okay. Berger wrote on an email to Mr. Sefton dated April 30th, which was after the April 27th meeting. Quote, at 10:15 a.m. on Wednesday, April 11th, 2007, I received a call from Paul Morrell. During that phone conversation, Paul asked me to contact my counterparts at the centers to find out if those who recorded the meeting still have their recordings or if they could retrieve them. Paul wanted me to ask them to erase videotapes or shred DVDs of their recordings. And this was an email from Fred Berger to Keith Sefton. Mr. Wholley, were you aware of that email?
No, sir, not at the time.
So your deputy didn't tell you this?
Sir, to be honest with you, I was trying to stay away from, in fact, well, the answer is I can't remember when I learned of it, but, you know.
What were you planning on staying away from?
I wanted to stay away from any involvement that, because I was involved in the destruction of tapes, I wanted to stay away from any involvement in talking to any of the witnesses. I wanted to, in fact, when the committee asked for any emails or any documents, I turned my computer over to another attorney in the office and said, this is everything I have, just take what you believe.
And which attorney was that?
That was Ms. Donovan.
Now,
And I believe she worked with her supervisor, Mr. Falcon.
okay, and Mr. Morrell, I've read you this email from Fred Berger, who was the technician that did the recording, to Keith Thomas Sefton, who works in Mr. Wholley's office. That is at variance with the testimony that you have given in the answer to my question. How can you explain that?
Can't explain it, sir. All I know is I asked where it was recorded. He said he recorded it at headquarters. He said that it had been given to Public Affairs, and I asked him to get it back. Never any...
I would repeat what is in the part of the email. Paul wanted me to ask them to erase videotapes or shred DVDs of their recordings, unquote.
I did not do that.
Okay.
When I had all the copies that were at headquarters, Mr. Berger gave me the final copies. I asked him, was this everything? And he said yes.
Okay.
And at that point, I knew I didn't know what needed to be done with them, so I took them to the General Counsel.
Okay. No, thank you, Mr. Chairman. I have no further questions.
Sweeney.
Mr. Wholley, I think it was at best a foolish mistake to destroy the videotapes. I want to make that clear. But I also want to ask you some questions. Is it your understanding that as part of a decision-making process before a final conclusion or decision or report is issued, that notes and documents that are used in terms of developing the final decision are subject fully to the FRA?
I'd have to look at that in context. I'm not quite sure I have the entirety of your question. Pre-decisional stuff?
Pre-decisional.
No.
And in the two letters that Mr. Griffin penned, the first letter of March 14, he says that one of the purposes is to have an opportunity, in quote, to listen to any concerns that may exist amongst the staff and to express my support for a strong and effective Office of Inspector General. In his subsequent letter to Clay Johnson on March 29, he says that he wants to make it clear that he is, in quote, committed to leading an agency where full and frank discussions are not just tolerated, but are expected, condoned, and encouraged. And it seems to me when I'm trying to have that sort of conversation with my staff, that a video recording is the last thing I want to encourage those sorts of full and frank discussions. And so, do you share Mr. Morrell's opinion that this meeting should never have been taped in the first place, given the purposes that Mr. Griffin laid out in those two letters?
Yes, sir, I share that. As I recall the conversation when he came in that morning, which was the morning of the 11th, with the copies that Public Affairs had made, as you could tell, his concern was that Public Affairs had no right to tape a meeting that was supposed to be a private, internal, closed meeting between the administrator and the staff of the Inspector General. And if I may, the first time I became aware, and this relates back to something Ms. Klemstine said, and the first time I became aware that there was an internal policy within the IG that their meetings are recorded so other people can see them was when I saw the IG's response back. I did not consider this an IG's meeting. It was an administrator's meeting.
And you were in the meeting.
So I walked in with Mr. Morrell and Mr. Griffin, and Mr. Griffin walked immediately to the front of the room, faced the audience, and began talking.
Did you know that the meeting was being recorded at that point?
No, I did not. I know there were signs up. I was sitting what would have been on the very far right of a semicircle. As Dr. Griffin looked, and Mr. Berger was in front of me. There may well have been signs. I just did not see them.
Our last two witnesses, including Ms. Klemstine, said that it was clear to people that were viewing the monitor that the meeting was being recorded. That was my understanding of her testimony. Did you know that, Mr. Morrell?
Yes, there were signs.
There were signs, but Mr. Wholley, you didn't see the signs.
I didn't see them. I mean, frankly, I wasn't looking for them.
Well, one can only wonder, given the fact that there were concerns that Mr. Cobb was in the room, apparently. There were concerns about the tenor of Mr. Griffin's remarks. One can only, but nobody expressed them at that meeting. One can only wonder whether it was the video, as much as anything, that may have intimidated some of the people that had concerns that they expressed after the meeting, but not at the meeting. And so, again, I want to say that at best it was a foolish decision, in my view, in retrospect, to destroy the tapes that should have not been made in the first place. But it seems to me clear that if I were having a meeting like this with my staff, video cameras on all of us would be the last thing that I would want to encourage full and frank discussions and concerns. And with that, I yield back to balance my time.
Thank you. Mr. Morrell, I also would like to encourage candor within your staff, but you believe that it would inhibit still candid discussions within the staff to have it videotaped, but having a discussion of the findings of improprieties, of the allegations of misconduct by the Inspector General Cobb with their supervisor, Inspector Cobb, sitting right there, would not inhibit the discussion. That could be free. That could be open. That could be candid with him sitting right there.
I didn't say that. I'm sure that some people may have felt intimidated by having him.
And do you think that inhibited conversation within that room?
Perhaps it did. It
Does
very
it make
possible
sense
fact
that it would?
Perhaps some people would be inhibited to speak up. People did ask questions. I thought perhaps some people there would have been more than what there was, but.
Well, the inspector, the guy they're talking about is sitting right there beside Administrator Griffin. Is that right?
He was not beside the administrator.
He was in the room. Okay. And they were talking about him. And they were talking about allegations of misconduct by him.
Correct.
And that, you thought, could be an uninhibited, free, candid discussion.
Mr. Chairman, I didn't say that. I can tell you that the administrator felt that if he was going to be talking about the IG should be in the room.
If you were concerned, Mr. Morrell, it strikes me if you were concerned about the candor in the room and making people feel that they should have an uninhibited discussion, say what was on their mind, that it was not the taping of it that inhibited that. It was having Mr. Cobb right there, and also the tenor of what we understand Administrator Griffin said. Now, we don't have a tape to see what he said. We have still not been provided the written statement that you said that he used, but
on the written statement, it was prepared from some talking points that we had prepared, and
can we get those?
You should have them already.
We do not.
I can get them to you, but they were provided, I believe, in the first set of documents that you requested.
All right.
It is not a complete document. It is a partial document of what he used.
All right, Mr. Morrell, Mr. Wholley wrote you an email on March 14th, which we have been provided, about this proposed meeting. The proposal in the letter to Clay Johnson that Mr. Griffin would address the Inspector General staff. It is before you as Exhibit 10. Do you have it?
Yes, sir.
All right. Do you recognize that email?
I do.
Okay. Can you read it through the warning that you not disclose it beyond the Congressional Committee?
I can probably get through it.
Okay. I would like to read from it. Paul, I wasn't very articulate in our discussion last night, and I apologize. Truth is, I am very troubled by the proffered addition to the letter. To call a, quote, special meeting, quote, of the IG staff and not be prepared to back Moose, that's the Inspector General Cobb, in a strong way would undercut Moose, grant more credibility to the complaints and the investigation than warranted, and be, I believe, counterproductive. On the other hand, to call a special meeting and praise Moose in front of the selected group, the IG staff, will risk Mike becoming the center of the controversy, Mr. Griffin, Administrator Griffin. As I said last night, I see no upside for Mike in the proposed course of action, and I do see a downside. I know that this is not a legal matter, but I'm concerned about how this will play out if the suggested course of action is adopted. Do you remember getting that email?
I do.
Okay. Did I read that faithfully?
I believe so.
All right. Do you recall the conversations that you had with Mr. Wholley?
Vaguely.
Okay. Do you recall the email?
Yes.
Okay. Did you have the same concerns?
I raised this issue with the administrator. He did not believe that he was going there to defend the IG or to criticize the IG, but to talk about facts, and it was something that he decided he wanted to do.
Okay. Well, the reaction that the previous two witnesses, Mr. Winters and Ms. Klemstine in particular, described, aren't those exactly the reactions that Mr. Wholley was concerned would result from such a meeting?
I believe so.
All right. Did you share those concerns? Did you have the same concerns that Mr. Wholley had?
I don't believe at the time I did. I believe that the administrator would go in, discuss facts, what he was asked to do, what he decided to do, and what his expectations were for the office, as he stated in his letter.
All right. All the testimony today has been that there were signs everywhere. Let me not exaggerate. There were visible signs, readily visible signs, saying that the meeting was being taped. The two previous witnesses said that they noticed the signs. They assumed that the meeting was being taped. Did you notice those signs?
I did.
All right. Why did you not say at the time to stop the taping of the meeting?
When I noticed that the administrator was already speaking, Mr. Berger was at his console working, and I decided it wasn't appropriate to interrupt the meeting.
I have abused my time again, Mr. Sensenbrenner.
I'll yield the chairman my time.
All right. Why did you've collected the DVDs? You took them to Mr. Wholley. Why did you take them to him? You said that you didn't specifically say destroy these. What did you say?
I believe what I told. I recapped what had happened. That I didn't ask. I asked that the meeting not be recorded. Public Affairs had apparently put in a request. I thought it was inappropriate. And believe that Public Affairs had any authority or legitimate reason for doing so. That I collected them, taken from Public Affairs, and I had them, and I didn't know what to do with them.
What did you expect Mr. Wholley would do with them?
Part of the reason I brought them to him was because they had maintained the records on the IG investigation, and I figured he would be, he and his office would know what to do with them.
Did you say that to Mr. Wholley? That because he was maintaining the other records pertaining to the...
No, what I asked him was what should I do with these?
And he said, leave them with me?
Yes.
Did it not occur to you that he might infer from your conduct that that you wanted them destroyed? I mean, it seems like you came powerfully close to saying, will no one rid me of these troublesome DVDs, these meddlesome DVDs?
No, sir. That was not my intent. It was never my intent to destroy anything.
Did you ask Mr. Wholley if you could throw the tapes away?
No.
Did you ask him if the tapes could be destroyed?
No.
Did you ask him to research the law on what needed to become of the tapes?
I believe as I was leaving, he said he was going, something to the effect that he would look into it or something to that effect.
Mr. Wholley, how many lawyers reported to you at that time?
In the Office of General Counsel?
Yes, sir.
At headquarters in the neighborhood of 35.
Were there others in other places within NASA?
Yes, there are attorneys at all 10 centers.
And how many attorneys in all are there?
Approximately 152 at this time.
152 lawyers? And 35 were right there at your elbow?
Yes, sir.
Okay. Did you ask any of them to research the law on your behalf?
No, sir.
You did not give the research assignment to any lawyer?
No, sir.
You looked at the books yourself?
Yes, sir.
Generally, I applaud that in lawyers. It doesn't happen often, but... Do you have a background in FOIA or records law? You said earlier you're not familiar with the case law that Mr. Sensenbrenner referred to you. Is that an area that has been an area of specialty for you or concentration?
Certainly not a specialty, sir. In terms of my past time serving as staff judge advocate at various commands and serving at headquarters.
Were there lawyers within the 160, however many, who reported to you who did have that as an area of their concentration?
Yes, sir. That would be the general law section.
The general law section, but you did not inquire of anyone in the general law section?
I did not.
Why did you not?
Well, I guess one reason, it was a very sensitive matter. As my attorneys will tell you, I do a lot of my own research even after they present a product, although it's not a question of not trusting them. As you may have gotten from my statement, I'm a show me the data, look at the law. I looked at exactly what Ranking Member Sensenbrenner said, 443301. I looked at the FOIA, and sir, as I mentioned in my written remarks, I didn't start on this right away. It was sometime later that day. There were other things going on. It was sometime later that day. From my perspective, these were recordings that were made by the Public Affairs Office of a private, closed meeting of the administrator. They should not have been made.
All right. Mr. Wholley, Mr. Morrell discussed the email that you sent him before the meeting that I read aloud. Do you recall that email? Do you recall your conversations about your concern about how it looked?
I don't recall the conversation from the night before. I do recall the email.
Okay. So you expressed a concern in the email about how it would all look one way or the other?
Yes, sir.
Okay. And so that was... were you present? You were present at the meeting, correct?
Yes, sir, I was.
Okay. Were you aware then of the concerns that Ms. Klemstine expressed and Mr. Winters expressed that the staff members felt about what was said at the meeting?
No, I was not aware then, sir.
Well, hearing what happened at the meeting, did you have any of those concerns yourself?
No.
But you did know that there was a very strong potential problem, one way or the other, of this meeting not looking good. Of either if Administrator Griffin said, Moose Cobb is my boy, or if he criticized Moose Cobb to his own employees.
Yes, sir, I had concerns. They were expressed in the email.
And you knew at the time that this was a subject, at that point, Senator Nelson, Chairman Bart Gordon, and I had all urged the president to fire Moose Cobb. You knew that, did you not?
I'm trying to put, I believe your letter was, that particular letter was early April, April 3rd perhaps?
April 2nd?
2nd?
So that was before the meeting?
Yes, sir.
Okay, it was before the tapes were destroyed?
Yes, sir.
Okay. You knew that how this whole matter was being handled was something that the oversight committees of Congress were interested in, did you not?
I knew they were interested in the matter, yes, sir.
Okay. And you said that you did not want this to be subject to FOIA if you kept it. Isn't that right?
That is what I said, sir. That's only half of what I said. I said I did not believe they were agency records. But if we retained them, they would become agency records. From my perspective, we had 5 copies that Public Affairs had made of a closed meeting between the administrator and the IG staff that was not only not authorized, but was specifically said not to be recorded.
Yeah, will the chairman yield?
Chairman happily yields.
In what part of the Federal Records Act is it intended to encourage agencies to destroy records promptly so that they won't become records? Is there any clause in that? I haven't been able to find it.
Sir, I've never looked for that clause, nor have I been able to find it.
Oh, it isn't there. I yield back to the chairman.
Thank you, Mr. Sensenbrenner. Mr. Wholley, you are also a lawyer. In fact, you're the general counsel of NASA. Are you familiar with the evidentiary concept of spoliation, S-P-O-I-L-A-T-I-O-N, spoliation?
Yes, sir.
Okay, and describe that concept for me.
Basically, inferences can be taken negative to the person who fails to provide certain evidence.
And certainly destroys it, knowing that the documents are subject to would be evidence in a pending litigation or anticipated litigation or an inquiry from Congress.
Yes, sir. May I continue?
You may.
I don't know how to get this across any more clearly. At the time that I, having finished my research, which we now may say was not sufficient, at that time, I did not believe they were federal records. I did not believe Public Affairs should have copies. I did not believe there was any reason for these copies to exist and be filed, or they could become federal records and possibly foilable. And as perhaps impossible as this may seem, I did not consider, truly, my bust. I did not consider the political aspects of this. Nobody, as I've said, nobody regrets more that I can't produce that particular DVD.
And you are aware that now there are employees of NET. You spoke of it, or you wrote of it in your written testimony. You did not get to it in your oral testimony. That there are employees of NASA who attended that meeting who are now providing us with accounts of the meeting that you described as patently ridiculous, outrageous.
Sir, your staff informed me of several allegations that were patently ridiculous and outrageous.
Knowing everything that you knew then, knowing that this meeting was in its very conception a problem, knowing that we were interested, Congress was interested, the oversight committees were interested in how NASA dealt with the PCIE recommendations, knowing that we would likely eventually ask for that DVD if it still existed, why is there not every element of spoliation present? So we should assume the worst under ordinary rules of evidence.
I cannot stop you from assuming the worst, other than to say, sir, that there were 120 to 180 people in there, many of whom were NASA IG investigators. There was certainly no intent on my part to destroy evidence. Frankly, that just was not my intent. As I've stated to your staff, and as I'll state here, what I did in good faith. If it was a mistake that I made on the law, it's probably not the first one I've ever made, nor will it, unfortunately, be the last. But it was an honest mistake, and I deeply regret that I destroyed them for the reason that we are now here debating this.
Okay. Is it your practice to destroy other federal property?
No, sir.
Have you done it on any other occasion?
Not that I can consciously recall, sir.
All right, and how did you do it in this case? Exactly how did you destroy those DVDs?
Broke them in half, threw them in the trash.
Mr. Sensenbrenner? Mr. Wholley, in addition to your email to Mr. Morrell, you sent an email to Jeff Rosen, the counsel at OMB for Clay Johnson,
Yes, sir.
dated April 4, 2007.
I do not recall that particular
Okay,
email, sir.
It's in the evidence book as Exhibit 18B, the exhibit book.
So my number 18 is the
18B.
bullet points. Oh, I'm
18B.
sorry, 18B. Yes, sir.
All right, the subject line is hearings with 2 question marks.
Yes, sir.
Okay. Now that was 2 days after Senator Nelson, Chairman Gordon, and I called on President Bush to fire Mr. Cobb.
Yes, sir.
Okay. And in the email, you were point out the subject of the Cobb case, and you wrote that the Cobb case continues to spin up to escape velocity, and the reason for this email is to arrange a meeting between the 2 of us and anyone else you care to bring from your staff who's been involved in vetting this investigation before there is any hearing, so we can soberly consider the approach to be taken. I am sure that you can appreciate that I am not particularly keen on seeing 2 entities of the executive branch at odds in a hearing before the legislative branch. So you were aware that this would likely be the subject of congressional hearings?
No, sir. I cannot say I was aware that it was likely.
That it was possible?
Possible, yes, sir.
All right, that if it was likely, there just would have been 1 question mark. Possible was 2 question marks. So you were certainly very, very aware of Congress's interest in this, this committee's interest in this, and you were getting together with OMB to kind of get on the same page?
No, sir. My concern, which I had expressed since you have all my emails, you know, my concern was concerning the disconnect between the executive order, the Integrity Committee policies and procedures, and what had actually been produced and what transpired. That was my concern, not the hearing, sir. I mean, you call a hearing, I've given you everything that I have on my computer that my attorneys believe is relevant. I'm here to answer any question you have. My concern was about the way the executive order and the policies and procedures were not properly interfacing in the way that the investigation came to us.
All right, I'm sorry. I'm sure that you can appreciate that I'm not particularly keen on seeing 2 entities of the executive branch at odds in a hearing before the executive branch.
Yes, sir.
What was it you were concerned that OMB and NASA might be at odds about?
It wasn't so much OMB, sir, it was the Integrity Committee and the PCIE. It's not OMB. I was talking to Jeff Rosen, Mr. Rosen, in his capacity as a counsel to Clay Johnson, chairman of the PCIE. He was well aware, as were others, of my concerns about the executive order and the policies and procedures, and how they were or were not interfacing properly.
Mr. Wholley, could you describe what your role was in the response by Administrator Griffin to the findings of the PCIE, the report of the PCIE?
I was given the package, sir. I was given the package by Mr. Morrell. As I said on my emails reveal, it was the 26th. I did review it. I turned it over to someone who knew nothing about it, a very experienced attorney, and asked for her unvarnished opinion on it. I had her brief Dr. Griffin. I was in the room. At the conclusion of her brief, he asked me my thoughts. I explained I was on all fours with her analysis, which had been done independently. We had previously or simultaneously given him the range of options. As you know, sir, he has no disciplinary options, which is why his letter talks in terms of with the concurrence of the chairman of the PCIE. And that was my role, sir.
What was the standard that the attorney that you referred to used in her analysis? Was it one of criminal misconduct, or was it one of appearances?
I believe she'd be better able to answer that, sir, but I do know that she had the policies and procedures with the definitions therein. She had the quality standards for inspectors general. She had the executive order. She had everything I had, and she had a number of years of experience.
I'm sorry.
I'm sorry. I don't want to speculate. I was going to say I doubt she used criminal law standards, since any criminal law violation, I assume, would have been given to the Justice Department. And as you know, sir, the investigation specifically says there is no violation of law, rule, or regulation, gross misconduct, or gross waste of funds. They did say there was an abuse of authority in creating a hostile work environment.
Just one more set of questions, Mr. Wholley. I know in your written statement and perhaps in your oral statement as well, you said that you did not socialize, you did not visit with Mr. Cobb in his home, he did not visit in your home, you did talk whenever you saw each other. Did you have regular meetings with him to discuss matters before your office or before his office?
Yes, sir.
Okay. And how often was that?
Well, I would say probably it would be rare that if I didn't see him once every couple of weeks.
Okay.
Probably more, weekly, 10 days.
Did you tell our staff that you met once a week from the time that you joined NASA?
Yes, sir. Initially, we did have weekly meetings when there were weekly meetings between the administrator, the parties that were supposed to be at the meeting were the administrator, deputy administrator, chief of staff, inspector general, and general counsel. That had existed before I got there. More often than not, the administrator wasn't there. It was the deputy chief, and this is prior to Dr. Griffin arriving.
All right, and did the two of you compare notes on your discussions with our staff?
No, sir. Compare notes, sir?
Well, that's a phrase. Did you talk with each other about the interviews?
I think we said something, but it was not, frankly, it was not what I'd consider anything substantive.
Okay. And you're familiar with all of the allegations, not just the summary report, but all the allegations within the file of the PCIE matter. The Inspector General began as an Inspector General's investigation by the Inspector General of HUD. Have you reviewed all of that?
Sir, I reviewed what I was provided, what NASA was provided. I reviewed that. I don't know if I have everything. I was, as I mentioned to your staff, I dealt with the pile of wood that was given to us.
Well, allegation 43 in the record of investigation, again, it's an allegation, was that Mr. Cobb had improperly provided you information pertaining to criminal cases.
Yes, sir.
You were familiar with that allegation?
Yes, sir.
Okay. And you are familiar, you know that one of the principal concerns about Mr. Cobb's conduct at NASA was the inappropriateness of his relationship with Sean O'Keefe and how close it appeared to be rather than an arm's length independence.
Yes, sir. And again, I believe Mr. O'Keefe left in February of 2005.
All right. Did you seek advice from Mr. Cobb on how to manage your own staff, how to lead it, how to deal with challenges? Or did he seek advice from you on those matters?
He did not seek advice from me, no, sir.
Did you discuss it?
We discussed leadership at times, sir.
Okay, I have no further questions.
Neither do I.
Okay. I thank both of you for appearing and for your testimony. I believe that Mr. Sensenbrenner and I have already discussed further action that we may take.
Thank you, Chairman Moore. Mr. Sensenbrenner.
That was